on the record, and this is with regard to Nancy Burke, PDJ 2025-9099. If our counsel can announce for a record. Yes, ma'am, Tracy Schmidt, bar counsel on behalf of the state. You, and then Ms. Burke, if you could state your name for our record.
Nancy Burke here, pro.
Thank you. Okay, so I set the status conference on in an order filed on April 23rd. And there's a number of other things we need to deal with, but the purpose initially for setting this was Ms. Burke emailed Rule 122H notice. And so, Ms. Burke, I had indicated that I anticipated giving previous filings that the state bar made and previous discussions. Your intention may be to broadcast the proceeding. So let's just start there. Can you clarify what your intention is?
Yes, and thank you for the chance to do that. It is under 122H that I intend to record and hopefully broadcast as well. And I'm glad you asked me that because I did see in the notice that was filed April 23rd that we were going to talk about 122D today, which I think that's regarding photographs and video, and I don't intend to have any videography, photographs, press coverage, anything like that, just the audio only under 122H.
So I'm gonna just read 122H. And so it says a person may use an audio recorder during the proceeding. The person must notify the judge or the judge's staff to using the device. A person who uses a personal audio recording is not required to submit a request under paragraph C of this rule. A person who wishes to record or broadcast the audio portion of the proceeding with the device that is not on the person, they must do so.
Mm.
The personal audio recorder must not be obstructive, distracting, or otherwise prohibited. And use is subject to the prohibitions of paragraph A of this rule. Paragraph A, a person is not permitted to broadcast a proceeding in the following circumstances. And then it lists out various circumstances. So let me first turn to Counsel Schuman. You've heard what Ms. Burke's intention is with regards to her notice. And so what is your position?
This is our objection to the request to broadcast. As the court requested in the order, I secured the position of my witnesses that I intend to call at the hearing, which at this point, in addition to Ms. Bork, would only be Mr. Stachel and the complainant in this case, Mr. Tepner, both of whom object to the request. I have not determined whether or not I would be calling Mr. Contreras as a witness, but I did secure his position as well, and he does object to the request. And I believe the court would know because Ms. Bork actually filed her disclosure statement, I believe, with the court, but she's identified the two minor children as witnesses, and one of whom is a biological child of Mr. Contreras, and I did confirm that he objects to not only his son testifying, but for purposes of this status conference, would object to his son, if allowed to testify, that being in any way recorded and disseminated.
So is it the state bar's position that when H says that one is not required to submit a notice under paragraph C, that does not the ability for a party to object, or the courts need to analyze whether the broadcast should be permitted?
I do not do believe that that obviates that need, because there are also other considerations that I think that the court would need to take into consideration in determining how to rule on that request. One being, there is an issue of practicality and how that would work, given that there it appears as though Mr. Bork will be trying to introduce evidence regarding a post family court proceedings that are in the seal. They could be addressed through any order of the court. And then the state bar will be objecting to Ms. Bork to allow the minor children to testify, if in fact the committed position would be that that testimony should be sealed and not broadcast. So I do think that the court needs to go through the consideration as it determines whether or not to grant that request.
Okay, and I recognize that I'm pronouncing the respondent thing differently than the state bar. So, if the respondent, if you could just tell us the proper pronunciation of your last
It's just Burke. It just looks like Bork. It's confusing.
name. I knew I had gotten it wrong.
That's okay.
Right. Before I said it's Berg.
It is just Burke.
I just wanna call you by the right name. So
No problem.
Ms. Berg, I'm from I think some of your pleadings or maybe just your last statement. I'm gonna infer that you and I'm gonna find for the record that you've articulated an objection to the PDJ doing an analysis under D of Rule 122. Having said that, I want to give you an opportunity to address the consideration. I did not speak to a notice that Ms. Newman had filed after a previous hearing where a recording came up. Notice suggested that you had went ahead and broadcast a previous hearing. So that's something that I do need to take into consideration under D1. And then the other things that she just described. And so I want to give you the floor to provide any additional information that you want me to consider with regards to D1.
D1? Okay. Let me quick, sustaining coverage. Okay, so D1 for coverage under C is what you're asking me about, right? I just want to make sure.
The order is so that you were prepared. I will tell you my story. I have another hearing.
Okay.
And we've got a lot more to get through. So I'll just tell you that D1 indicates that I'm to consider the impact that the coverage might have on the right of any party to a fair trial. In fact, the of not only a party, a victim, or a witness.
Right.
The impact that the coverage might have with regards to safety and well-being of any party, victim, witness, juror doesn't apply. The likelihood that coverage would distract participants or that coverage would disrupt or detract from the dignity of the proceedings, the adequacy of the physical facilities, the timeliness that's requested of the request, and whether the person making the request is engaged in the dissemination of news to a broad community, and any other factor affecting the administration of justice.
Okay. Well, okay, I didn't make my request under C, and so I don't think that D applies, but I will try to address them to the extent. I think my understanding is that the state bar is is invoking that. So I'm sorry. I tried to write notes just now as Ms. Schumann was speaking. And then the state bar said that I would try to be introducing evidence that is under seal. And I don't know if that's how Rule 122C and D came up, but I don't intend to introduce evidence that's under seal. So I don't know if that falls into the 122D factors, too. And then under H and K that the court mentioned, I don't intend to use the audio recording while Your Honor is off the bench. There's no jurors under K2, no attorney conferences. There's been occasions every once in a while where I have had to pause my 122H recording because judge goes off the bench or there's an attorney conference, more often where the judge goes off the bench. But I know of those factors and I can easily pause the audio recording on those times. And then that's under K4, but it's going to be audio only under 122H. So that's not going to be an issue either. And then no juvenile proceedings. I mean, we're not in juvenile court. And this is just in terms of the state bar proceeding that I'm asking for notifying of the 122H coverage. And then I'm not asking for coverage under 122C, but I am scrolling back up. And then I just want to make sure, did someone else submit a 122C? And that's why you're asking me about D, because I want to make sure I'm looking at the factors under.
Don't read them I don't read the rule to say that that D only applies to requests under C.
Oh,
So
okay.
now's the time.
Oh, I see. Okay.
But I gotta tell you, we got 15 minutes.
Sure,
We have
sure,
a lot
sure.
more to get to. So is there anything else that you wanted to tell me with regards to what I should consider?
Okay, so as far as my request under 122H and then looking at the factors under D1, I'll just state for the record, I don't believe they apply. But I will try to go through them to the extent the court finds differently or the state bar is arguing differently. So under D1, the impact of coverage upon the right of any party to a fair hearing. It's only me and the state bar are the parties, and for me, the impact of I don't believe it's coverage. The impact of being able to record and broadcast on me, the defending respondent, is huge. The entire Some idea of some of the other things going on. Generally, all of it has been impacted greatly and negatively and almost exclusively by the covering up of what I do absolutely, as far as I will not, absolutely not get one if I cannot record the hearing. I'm still having trouble even getting the recordings from the last one from the year 2025. And is getting me a little bit of the ways forward as far as the appeal of the last one, for example. I was able to record a hearing, and the Supreme Court just recently ruled a couple of weeks ago that I can recreate the record from my recording, and that wouldn't have been available. Yep, yep, yep.
You
Sure.
would say that as the evidentiary proceeding, the
Correct.
recording was provided.
Uh-huh.
The recording was provided.
Last time on substance, I only had one on the next phase. It's not sentencing, but correct.
Was recorded and that was provided
Right.
to you.
Right.
Given that we're having trouble maintaining time and
Sure.
right.
Uh-huh.
I'll give you 2 more minutes.
Okay.
Any other factor that you want to?
Well, again, I don't think that the D applies here, but as far as B, the impact of coverage upon the right of privacy of any party, victim, or witness, it sounds as though it's only the state bar is only calling my ex-landlord and my ex-landlord's ex-attorney. So I don't see how the audio coverage would impact them at all, but it would help me As far as my own, I don't want privacy. I don't want this done underground. I think that having a hearing, like Rachel Mitchell and just everybody has a public hearing, and there's reasons for that, and I think it's really protective of me and my entire family. Mm-hmm.
State bar said that you were intending to call minors. Is that correct?
For this case, I already did an interview, yes, and I disclosed that. Mm-hmm.
You intend to call 2 minor children, is that right?
As far as they have knowledge,
And the state bar, one of those children, she identified the biological. Do you disagree with who she identified?
as the biological father of one of the witnesses.
Correct.
I'm sorry. Yeah, I didn't hear who she identified, but my daughter's father's name is Richard Swartz. He already did an interview for this case as well. And then my son's father is Roger Contreras, and it sounded like the bar was not going. Okay.
Public hearing that, Ms. Burke?
And no, I'm having trouble just following the stuff that's outside of 120 and the relevancy, but yeah, the impact of coverage upon the safety and well-being of, like, for example, my son, Roger Contreras' son, absolutely.
For 2 minutes.
Yeah.
So we're going to move on to another topic.
Okay.
And so, while there's some other issues that we should address, I
Mhm.
think that they're kind of attached to the notice that you filed with regards to change of address.
Oh, sure.
So, from what you write in here, I just need clarity. Are you currently residing in Maricopa County?
That is my legal address. Mhm. Right.
I need a yes or a no. Are you currently residing in Maricopa County?
That is my legal residential address. Yes.
I didn't ask. I'm not asking you to
Yes.
disclose an address.
Mhm.
Wouldn't do that given what is in this document.
Right.
I need clarity from you as to whether or not today
Mhm.
you are living in Maricopa County. Yes or no?
I'm supposed to testify under oath that that is my residential legal mailing address.
Not the question.
I
Are you living in Maricopa County? Do you need me to define living? Do you want me to define living?
I understand the program requirements, and I am supposed to testify under oath that that is my residential address. Living.
So let me reframe the question. So I'll let you know that
Yes.
we had a previous hearing where you requested and exercised your right
Yes.
to have venue for an evidentiary proceeding
Right.
in Sierra Vista
Mhm.
because you had defined it as your residence. As you recall,
Right.
the state bar objected, given that during that hearing
Mhm.
and previous hearings, you had identified yourself as being homeless.
Mhm.
You then filed a document that I found satisfied,
Yeah.
demonstrating that you were residing in Sierra Vista or Coaching County.
Right.
The question becomes the reasons that we, under our rules, would set the hearing in a location other than the Supreme Court building
Mhm.
is because the respondent is a resident of that county as a law office there. We've already into that second layer doesn't apply. So I asked the question. It's framed as a yes or no. I'm assuring you that my follow-up is specific address in which you are sleeping at. It will tell you that for purposes of this review, we find that the venue is when resident means someone who is substantially living in that county And I define living as being the location in which one sleeps at night.
Okay.
You currently living in Maricopa County?
Um, um, I, I think under your definition, I'm right.
In Cochise County.
Um, um, sleeping. Yes, yes, it's living in that sense. Yes. I'm sorry. I'm really scared to say. I'm really scared.
I don't want you to say. I made that very clear, but I do need to make sure that I am following the rules that the Supreme Court provided me with regards to venue. The state bar has already raised concerns about the cost. And so you have given me,
Okay.
and I will tell you that if that changes, you need to notify us in a pleading. Again, you would not need to provide us this. You need to know which county you are putting your head down on a pillow at night if it changes. And I use the term substantially on purpose to clarify. If you go on vacation, we don't need to know. If you feel at some point that you need substantial is, we can go through that. But right now, I'm not going to then revisit where the hearing, the evidentiary hearing is set. We're then going to transition to
Okay.
I'm just trying to
Thank-
the document labeled motion for order permitting the state bar to take respondent's deposition by remote means on May 22nd. I didn't see a response from you, Ms. Burke. So am I correct to infer that you no longer have an objection to it being a deposition by remote means?
That's not why I didn't respond. It's chaos of getting my phone and everything under the provisions, and
Position with regards to their request to do the deposition on June 15th by remote means.
I have those factors in front of me. I do know that my I'm sorry. I'm sorry.
Are you objecting to the deposition being done by Zoom?
On that date, I think my ex-husband has hearings all day long in Cochise County at this time. I think he has hearings all day long that same day. Um, I necessarily a remote. I need to gather up those different dates. I do believe that he set hearings for all day long in, I think Bisbee for all day long, uh, related to wanting to never have my children, things like that.
You have proceedings?
Yeah, I think.
I don't care about your ex-husband. I care about you.
Okay. I think I do for all day. I have to nail down when precisely they are. There was a notice that it was going to be all day, and then there were additional hearings set on top of that. And I'm not sure about the timing, but I think the additional hearings that were set for that day is Monday. Yes, I'm sorry.
We're almost to the end.
Sorry, I'm
What I'm trying to sort out is pleading.
yes,
You objected to your deposition being done by Zoom.
yes,
I denied the state bar's request.
yes.
You scheduled a deposition on June 15th at 1 p.m. It sounds like you want to talk about the date and time. I want to first
Okay,
understand
sure.
if you object to the position in the future after today. being done by Zoom?
I don't think so on my own, because that is an ongoing issue. Having to get my own evidence in my own hearings by paying for court reporting fees. Um, and so that I can prepare myself after the deposition. And as
Ms. Schuman,
yes,
do you have any objection to Ms. Burke recording the depositions separate from the court reporter?
I do not know the appropriate certified transcript afterwards to personally record her deposition at the same time. I don't have an objection to that.
So Ms. Burke, though, that does not include broadcasting it, but
right.
having said that, okay, so then you and Ms. Schuman can deal with the June 15th date. I'm going to indicate that by stipulation of the parties that the deposition, your deposition held remotely. The state bar has already indicated that they will have a reporter. Ms. Schuman just reiterated that. So there will be a written record that will be created. Are there other issues that we need to address today?
I would like if Ms. Burke is live broadcast deposition. So I just wanted to clarify that, and then would ask if we could set a deadline by which Ms. Burke needs to get, as a practical matter, I need to get this stuff because we're fast approaching the hearing date, and so could we have a deadline by which she would advise me of dates that week that she does not have a conflict, something so that we can make sure that this proceeds timely.
So, Ms. Bird, I find that the state bar put on notice second of the June 15th, 1 p.m. date. You didn't file a to the request for me to make a ruling with regards to being remote. Under the rules, you really have, by not responding, and I would find that you've agreed to the June 15th at 1 p.m. If you are able to determine that you have a court proceeding on that same date and time, I'm ordering that you notify Counselor Schuman in writing by 4 p.m. today. If you do not do that, we'll be finding that you are on notice of, by not responding, agreed to participate in the deposition on June 15th at 1 p.m. by Zoom meeting. Do you have any questions or any where we end our hearing?
I don't know. Ms. Schuman said that we would have time to talk about how the exhibits would be exchanged under the Part B of, and Part C of that rule was who may attend.
Do that. It'll probably be good if you called her as soon as we disconnect. Anything else?
I don't intend to broadcast. I'll put that on the record. Not the deposition.
Okay.
But the attendance would be an issue if I'm in court. Otherwise, then there would be other people there. So I just, that's the only objections I would have to the and we just haven't figured that out yet.
Okay, well, I will tell you that unless you file or send something in writing to Ms. Schuman by 4 p.m. today, if you can participate by Zoom on June 15th at 1 p.m., file a request for sanctions, and there are a number of potentials that could happen
Okay.
with sanctions. They do have a right to your deposition, so I'm not sure why we're having the confusion or concern that you might need some kind of paperwork with regards to that. Councilor Schumann, I'm assuming that you're planning on giving Ms. Burke by the Zoom connection prior to June 15th. Do you know when you'll be providing that to her?
Yes, ma'am. Based on the discussion, what the court is indicating, we can get that email set up and emailed out to her yet today, but at the latest tomorrow.
Okay, with that, then I will be talking to also the final case management conference. To be clear, I've not altered any of our schedule, and with that, we'll stand in recess in the
Could-
matter. Thank you so
Can
much.
I ask one question? I'm sorry. Am I just I'm sorry. Could I just ask, am I sending the June 15th here? Am I sending that to the court or just to Ms. Schumann?
What?
The
What is it that you're asking?
about the court date for the multiple court dates that I have. Am I sending that to Ms. Schumann or am I sending?
If you're referring to what I just ordered you to do, I am ordering you send Councilor Schumann an email if you were unavailable on June 15th at 1 p.m.
Okay.
by 4 p.m. today.
Okay.
And if you are unavailable because of a court proceeding, is what I indicated,
Okay.
then you have an obligation to find a date as quickly as possible. Ms. Schumann has asked if that's the situation,
Okay.
that you provide her dates and times that you are available. And I will say that your availability needs to be provided through the end of this month.
Okay.
So that she can set a date when you are available, because that deposition needs to be done.
Okay. Understood.
We will stand in recess. Thank you all.
Thank you, ma'am.